Good afternoon, everyone, and welcome to this week's discussion and update on COVID-19 webinar. My name is Kathy Purdy, and I am a marketing manager here at Schoeneck King. Just two quick housekeeping items to go over before we get started. Please enter your questions through the Q&A box located at the bottom of your screen, and we will do our best to address those throughout today's program as time allows. If you would take a moment to complete the brief survey once today's webinar has concluded, we would appreciate that. Our attorneys do look at them and appreciate your comments and suggestions for future topics. So to start today's program, I'm going to hand it over to Pete Jones.
Thank you, Kathy, and good afternoon, everyone. Happy holidays from all of us at Schoeneck King. We got a full program again today, a lot going on, so we're going to kick it off with Jeff Shear. Jeff's going to bring us up to date on some of the key provisions from the bill that just apparently passed Congress and is awaiting the president's signature. Jeff?
Great, thanks, Pete. It's great to be back on the program and presenting to everybody. So we are going to hop right into this because, as Pete said, this was stimulus. The new stimulus act was just passed yesterday, and there are lots of changes to the Paycheck Protection Program that a lot of people are asking me questions about. So my first thing I'm going to say is this, that the law just came out last night. It's like 5,000 pages, the first couple hundred of which deal with the PPP Act. We are parsing our way through it. There are lots of changes, lots of things that we're understanding as we read through it. And also, as with the first time the PPP was passed, there are lots of things that are not very clear. The SBA has 10 days to give us additional guidance. So I'm sure many of us are going to be holding our breath over the next 10 days, waiting for the new year. 2021 will bring good things, and hopefully it brings some clarity on what we're calling PPP2, and that we'll understand some of this better. But let's just hop right into it. The stimulus package extends the PPP from the end of this year through September 30, 2021, which gives people an opportunity to apply for funds either a second time or a first time. So this is technically a second draw of funds or a second wave of funds. If they're to be eligible, let's talk about eligibility first. If you are an existing PPP borrower, to be eligible, you have to have 300 or fewer employees. I'm not sure why they ratcheted down the number of employee limit for existing borrowers from 500 to 300, but actually maybe it was, I can't remember, but it's 300 employees for existing borrowers. I think that was the existing rule. Second part is you must have used all of your previous PPP funds. So if you got through your 24-week period with existing funds and you have monies left over, you will not be able to qualify for PPP2 monies unless you figure out a way to have spent those monies in accordance with the rules, and I'm going to get to that in a minute. The third piece, which is really important, is that existing borrowers to qualify for additional monies, you must show that you have had a decline of 25% or more of gross revenue for any quarter in 2020 as compared to the same quarter in 2019. So it's really important that not only do you qualify number of employees, but also qualify in terms of using your monies, but also have that decline in gross revenue. For new borrowers, and again, I understand I'm running through this quickly. As a note, we will have a client alert coming out later today, I hope, with all of this information. So let me just push that. For new borrowers, first-time borrowers, the rule there is you have to have 500 or fewer employees, not 300, but 500 or fewer employees. They've expanded the eligible entities to include all not-for-profits. There are certain rules that apply especially for organizations that are accommodation and food service operations. So they've expanded the list. One of the things they've also expanded, which wasn't the case the first time around, is that entities that are currently in bankruptcy can apply for PPP funds. That's something that we are currently parsing out also to make sure whether it's Chapter 11 or 13 bankruptcy, but this is something that's different than the first time around, which if you were in bankruptcy, you were not permitted to get PPP funds. You are permitted this time around. The next big change on this is that there is a limit to the PPP funds that you can get. The limit this time around is a $2 million cap. So if you are an existing PPP borrower applying for a second round of funds, you are capped at $2 million total PPP funds. So if you got $1.5 million the first time, you're only going to get up to $500,000 this time around. If you are a new borrower, you can get up to $2 million of funds. And this is really meant to go after the small businesses and really to eliminate large businesses who hopefully are making it a little bit better, who knows, but really to make sure that the money gets to as many borrowers as possible. And that's why I think this limit of $2 million has been put in. You can still choose a covered period of 8 weeks or 24 weeks, meaning you can spend the money in 8 weeks, you can spend the money in 24 weeks. The amount of the loan, the maximum amount of the loan, just like before, is limited to 2.5 times your average total monthly payroll for the previous years. So that's the same calculation that went in before of what your maximum is. So we've gone over eligibility, we've gone over amount of the loan. Let's talk a little bit about what you can spend the money on. This is a big change from before. If you all remember before, you were limited in what you could spend the money on before. It was like payroll, mortgage interest, utilities, rent. This time around, they have expanded the purposes for which you can use the money. These purposes apply to existing borrowers who have not yet applied for forgiveness. So if you are an existing borrower and you say, you know what, I haven't spent all my money for whatever circumstance, on the original reasons, now you can actually cover, there are 4 additional buckets of where you can spend money. One is certain operations expenditures. These are payments for business software or cloud computing that facilitate business operations. The second is property damage costs. So if you were, if your property was damaged in some sort of uprising and it wasn't covered by insurance, you can use PPP monies for that. Third is supplier costs. This seems to be a very broad topic where you can costs for expenditures made to a supplier of goods pursuant to a contract order or a purchase order that was in effect before the date of the covered loan. So I'm not 100% sure what this means, but what I think it means, if you had a supplier contract in place, that contract was in place before the date you got your PPP loan, you could use PPP monies for that purpose. I'm sure we're going to see some expansion of that definition. And lastly, you can use PPP monies for PPE costs, personal protective equipment costs, which could include a wide range of operating and capital expenditures that you incurred for the benefit of your employees. So I think that's really important. If you haven't spent the money, these are additional reasons why you can spend the money. And if you apply in the second round, these are 4 additional buckets that you can spend money in. The loan forgiveness application has also been simplified. If you are a borrower, have a PPP loan of $150,000 or less, there is going to be a simplified forgiveness application process, which is going to be much easier than what we're seeing. I was hopeful that there'd be another simplified process for loans between $150,000 and $2 million, but that did not come through in the final legislation, unfortunately. The simplified process is only for loans under $150,000. So if you do have a loan under $150,000 and you have not applied for forgiveness yet, I would kind of wait and hold the reins on that and wait till they give the final guidance on that, then apply for your forgiveness. Another major change was that previously, if a borrower received an EIDL advance, you had to deduct that advance. It was $10,000. You had to deduct it from your PPP forgiveness amount. That deduction is no longer applied. So that's $10,000 of additional monies that you can gain forgiveness on. And one of the big changes, and I saved this for last as far as like the review here, one of the big changes is that it has now been put in the statute that that expenses that you have incurred using PPP funds are eligible for tax deductions. I think everybody remembers before that previously the IRS came down and they said if you use PPP funds on payroll or other expenses, you could not deduct those expenses. And a lot of us were pretty upset about that because it kind of changed the tenor of the legislation. But included in the statute is the fact that you may claim a tax deduction for eligible PPP expenses. This is a tremendous change. I think it's really going to help people this year in 2020 with their tax obligations. Hopefully help people next year with respect to PPP2 funds should they try and get PPP2 funds. If I could actually say it, that would be helpful. So that's a really quick overview of the law. As I mentioned to some colleagues, as we kind of parse through this, we're finding other things to highlight. We will issue a client alert at some point later today with everything that I've mentioned. And as the SBA issues additional guidance and FAQs, you can be sure to see additional information from us. I'm sure we're going to be on future Tuesday morning, or today's Tuesday morning webinars, giving updates on this, again, about eligibility, amount, what you can spend the money on, and how to gain forgiveness. And with that, I'll turn it back over to Pete, and we can go on with the program.
Thank you, Jeff. There were a few questions in the chat. I think you hit them all to the extent they are answerable. So thanks for that. A lot of information in there. We are going to turn now to Stephanie Fedorka. Stephanie is in our Syracuse office, and this is really the second part of our observations on the program, some of the employment implications. Stephanie, take it away.
Good afternoon, everyone. Thanks, Pete. I think this is a part that everyone's been eagerly awaiting. I'm going to talk about some of the key provisions for employers that we've seen, again, on our initial review of the quite lengthy bill. As Jeff noted earlier, it's 5,593 pages that was posted. Finally, there were some issues with distributing it and posting it on the website. So it was finally posted yesterday afternoon. So we were able to take a look at it. It is currently awaiting signature from the president, as Pete has noted. Kathy, could you change to the next slide, please? So again, this is a 30,000-foot view of our initial read of the legislation and the bill. So paid sick and family leave, there is no extension of the FFCRA paid sick and EFMLA leave benefits. Those will expire on December 31st as planned. However, the bill does include an opportunity for employers who want to elect to continue FFCRA benefits to reap the benefit of that tax credit that is available for employers who provide the leave. Again, as of January 1st, covered employers who voluntarily provide the leave, it would have to be the same type. It's like an extension of the FFCRA leave. This is not a reinvention of, I want to make my own type of paid family leave or paid sick leave corresponding with COVID-19. This would be virtually an extension of the FFCRA provisions, but it's voluntary for employers. If you so choose to do that, then you can take advantage of the tax credit through March 31st of 2021. Again, note, this is not a renewal or an extension of the entitlement or the allotment for employees. So based on our reading as of now, if an employee has exhausted their 80 hours of paid sick leave, that's it for them. You cannot voluntarily choose to extend that and then reap the tax benefits for that. This would be for an employee who has not taken FFCRA leave or has some allotment still left over into the new year from January 1st through March 31st. If they take leave that they would have been eligible for, had the FFCRA been extended, then you can take the tax credits for that. Go ahead, next slide, please. Unemployment insurance, this is, brief again, $300 of federal UI benefits that are being awarded or now issued for eligible employees or people who are no longer employed. It's half of what was previously given, which was the $600, which expired in July, followed by the $300 emergency extension that President Trump provided for about 6 weeks. The $300 federal UI is going to be available for an extra 11 weeks. So it runs from December 26th through March 14th. There is a provision in the language that provides unless that an individual has not exhausted their maximum benefit amount, then the benefits could continue through April 5th, 2021, but that is the hard cutoff date. So now the total weeks of federal UI available, we have the 13 weeks originally from the CARES Act, plus the 11 additional that are provided in the stimulus package. So for a total of 24 weeks of federal UI. Go ahead, thank you. And then lastly, there is, again, I am not a tax expert, I am not a tax attorney. I would highly recommend that you consult with your tax attorney, but this is something that I thought was a key highlight for employers to be aware of. The Qualified Disaster Employee Retention Credit has also been extended through July 1st of 2021, and there is an increase in that refundable payroll tax credit. It was 50% of wages up to the $10,000 max. Now it's 70% of wages, excuse me. So again, with respect to the tax intricacies, consult your tax professional if you have more detailed questions on that. But that's what I have for now, unless Pete has any other questions or follow-up.
Stephanie, thank you. Just a couple of quick observations I might, also ask you to comment on. So the things that people were and are concerned about, wondering about, include extension of the FFCRA, and the answer to that is no. There's the tax credit provisions that you mentioned, but we have not extended that. Which probably leads people to the next question of, what does remain, and that's the New York State COVID emergency sick leave provisions, which have been in effect since April. And for some employers, the new New York's paid sick leave statute could come into play as well. So one form of paid leave expiring unless you elect to continue it, but two others that will continue on here, at least in New York. And then the unemployment, I think, is another thing that's been on everybody's mind. So we've got an extension of time on that and also some supplemental benefits. So, I guess, the world changes, the world stays the same. I mean, some of these things are continuations of what we've seen, and others are, expiring or ending. Thank you for that update. Really appreciate it. The next thing we wanted to turn to was the travel question. I heard yesterday that more people are traveling over the recent period than at any point since the pandemic started. So, notwithstanding some of the recommendations and warnings, it appears that we're still seeing a lot of travel, which is going to create issues for employers. So Adam Mastroleo is going to walk us through, we're calling it a review, but it's really it's the rules. The rules that have been in effect for a while now, which were updated several months ago. Adam, take it away.
Thanks, Pete, and thank you again for having me. Travel is going to be another big issue come the first week or so of January. This was an issue back in back in November when Thanksgiving occurred, so we thought it would be helpful to review the rules. The way that I've always analyzed these travel questions is to start with what are the different types of restrictions or issues associated with travel from an employer's perspective. So you have quarantine requirements, you have testing requirements, and you have the New York State Traveler Form. And I think that if you go through each scenario and you look at each of those categories, that's going to help you with your analysis. So first of all, first scenario is travel to a contiguous state. So we know that travel to Vermont, Massachusetts, New Jersey, Connecticut, or Pennsylvania, if you have an employee or you travel to one of those contiguous states and you come back to New York State, what is required in terms of quarantine, the traveler form, or testing? And the answer is nothing. So if you travel to a contiguous state, there is no requirement that you fill out the traveler form, there is no requirement that you get tested, and there is no requirement that you quarantine. All right, second scenario. You travel to a non-contiguous state, so any other state other than the contiguous states, or you travel to a level 2 or level 3 international country. If you travel to one of those areas, then you have to look at the duration of your travel. So if you are outside of New York State for greater than 20, excuse me, I'll start with for less than 24 hours, you do not have to quarantine when you return. However, you do have to fill out the traveler form and you have to get a test on day 4. So you're traveling to Ohio, but you're out of New York State for less than 24 hours. You come back, you don't have to quarantine. You do have to fill out the traveler health form and you do have to get a test on day 4. So now the second area of travel to a non-contiguous state or a level 2 or level 3 country is if you are out of New York State for more than 24 hours. And here is where I would pause for a second. It's not that you are in this non-contiguous state for greater than 24 hours. The issue is whether you are outside of New York State for greater than 24 hours. We've had employers say, we've got an employee who's going to fly down to Florida and is going to drive back. They're technically not going to be in any state for more than 24 hours. Do they have to quarantine when they come back? And the answer is yes, because what the critical question is, are you out of New York State for greater than 24 hours? It's not whether you are in that other state for more than 24 hours. So if you're outside of New York State in a non-contiguous state or an international country with that's level 2 or level 3 for greater than 24 hours, you start with the default that anyone coming back has to quarantine for 14 days. That's the default. New York State has given individuals who travel in that manner the option to test out. In order to test out, you have to get a test within 72 hours of when you return to New York State. You have to quarantine for 3 days. You have to get tested on day 4. When both tests come back negative, you can come out of the quarantine. So this is the test out exception to the 14-day quarantine requirement. We've had employers ask us, does it matter which kind of test is taken? The answer is no. According to the guidance, there is no specific test that has to be taken. So that can include both types of approved tests by the FDA, the PCR test or the rapid response test. Another question that we've had is, well, what if an employee comes back to New York State and they get tested within 24 hours and then they get tested on day 4? Can they test out that way? And our response has been no, because this is an exception to the 14-day quarantine requirement. We're interpreting this to require strict compliance with the test out procedure. So you got to get the test within 72 hours of when you leave or before you come back to New York State, and then you have to get the test on day 4. So those are a couple of important points to make. One other thing I would mention is that everyone traveling to a non-contiguous state has to fill out the traveler health form. That's regardless of whether you're there for 24 hours or not. So that's something to keep in mind. Other questions and other issues that have come up in the travel context is the essential worker exception. This has changed through the various iterations of the travel guidance. The most recent travel guidance that we have was released by the state DOH on November 3rd. That is the guidance document that's been controlling for the past couple of months. So that's what we deal with. The first issue with respect to the essential worker exception is, are you an essential worker? And I would note that the travel guidance includes a specific way that essential worker is being defined. It's the last paragraph of the essential worker clause in that essential worker exception part of the travel guidance. It's someone who is employed by an essential employer, or there are other types of essential employees who might not be employed by an essential employer, but they are defined as essential. So that's the first question you have to answer is this employee an essential employee? If they are, then you might be able to take advantage of the essential employer exception. So what does that exception require or allow? It still requires the employee to fill out the traveler request form, or traveler health form, I should say. And actually on that form, there are going to be questions about whether or not the employee is essential. It also requires that the employee get tested on day 4 after being back in New York State. Early on, this caused a little bit of confusion for essential employers because they thought, okay, so the essential employee comes back, they have to get tested on day 4, but what about days 1 through 3? Do they have to quarantine for days 1 through 3? And our interpretation of the guidance has been that no, you don't have to quarantine on days 1 through 3 if you are an essential employee. You just need to get tested on day 4. So you got to fill out the health form and you got to get tested on day 4. Now, I am referring to the most common essential employee situation, and that is where you're a New York State resident, you travel to a non-contiguous state or a level 2 or level 3 country, and then you return to New York State. If you are an essential employee who travels for, or who is in New York State for less than 36 hours, there are separate rules, much less onerous, that are detailed in the travel guidance. But the most common situation is if you have an employee who lives in New York, they're going to be in New York long-term when they get back. One other note about the essential employee exception. The guidance makes it clear that although school employees and childcare workers technically fit into the definition of essential employees, they don't get the benefit of the essential employee exception. So school employees or childcare employees, although they're essential, when they travel to a non-contiguous state for greater than 24 hours, they have to quarantine for 14 days unless they can test out. Another issue that has come up that I wanted to point out was the international travel issue. So earlier iterations of this travel guidance said that international travelers didn't get the benefit of the essential employee exception. This has been done away with by the November 3rd guidance. So if someone travels internationally, they get the benefit of the essential employee exception, and they also get the option to test out as with any other traveler to a non-contiguous state. Pete, I think that is it for the relevant travel issues. I know we're going to see this a lot over the next week or so, and I'm sure your employees are going to be asking you questions about their travel and what they have to do when they get back. So hopefully that was a good overview for you. If you have more specific questions, please feel free to reach out. We're happy to tackle your specific situations one at a time.
Great, Adam. Thank you. The rules, good to keep those front of mind. I'm sure there will be lots of permutations. There are some in the chat. As Adam says, feel free to reach out to us to walk through your specific situation. Okay, before we finish with vaccines, which I know everyone has really been asking a lot about, so that's a teaser for you. We're going to go to Katie Anderson for the update from Albany. Katie, take us through this week, please.
Sure thing. I will also be touching a little bit on vaccines at some point. But first, looking at this bill, this enormous bill that passed last night, what is in it for New York State? It's a question that a lot of people have been asking. There was no blanket check for state and local government funds. That is something that the governor has been asking for since the beginning of this pandemic. But there is still, certain amount of funds that are allocated to New York. And these numbers are specifically what Senator Schumer said will be coming to New York State. I took this from an article in Newsday that's really does a great breakdown of what's going where. So first looking at that, $5.8 billion for public schools, colleges, and university. Most of that is to be allocated to elementary and secondary schools. And the other part of it is going to be allocated to colleges and universities. $4 billion to the MTA. The MTA asked for about 3 to 4 times that amount of money, but we will, obviously be watching that very closely. $1.6 billion for local governments for vaccine distribution, testing, and tracing. That will be a really helpful influx of cash for local governments, especially. Jeff thoroughly went into it, the $2 billion for the PPP, and then another $1.3 billion for emergency rental assistance. And remember, these are New York specific numbers. So this is what is estimated will be coming for New York State out of the bill. Looking at what happened, from Albany then this week on Friday. Executive Order 202.83 was issued. This order extends a lot of other orders, but it also implicates local governments and implicates restaurants or breweries or anybody who's had to be shut down for indoor dining in either an orange zone or in New York City. We'll start with that. Those entities, those restaurants that have had to be shut down for indoor dining, their sales tax is delayed to be due until March of 2021. Looking at the issues for local governments, this is about property tax exemptions. So there is, rather than having people come into the office, the tax assessor's office, to receive this property tax exemption, local governments may renew those 2021 benefits to all who received it in 2020, unless there's a reason to believe that that owner changed their address, passed away, or was married, or had a child. Those are all reasons that that exemption may not just be wholesale renewed. The vaccine update, just really quickly, in New York, yesterday the governor announced that there's been 38,000 vaccine doses administered in New York State thus far. According to the governor's numbers, that would put New York as the #1 state in terms of vaccine distributions. Nursing home residents and staff, that vaccination process started yesterday and will continue throughout the week. Looking at the number of doses coming from Moderna and Pfizer, we continue to see the amount of vaccines coming into New York increasing and increasing. It's set off quite a fierce lobbying fight in New York at this point, trying to be listed as, which are you going to be the essential worker that gets the vaccine? Is somebody in your industry going to have that? So it's going to be something to watch closely. The governor says that there will not be any politics involved in the vaccine distribution process, but we'll see. New York has a very robust lobbying enterprise on, an industry that's very different from most state legislatures. Most other state legislatures don't have that size of a lobbying enterprise. Looking at current data from New York, and I wanted to pull this up because it blends really well into what Adam was talking about with travel. When you're looking at the regions of New York State and looking at the positivity rate over, the 7-day average, those regions that are showing problems right now, it's the Finger Lakes and the Mohawk Valley regions that have really, you've seen increasing and increasing. Western New York stabilized after Thanksgiving, and I wanted to bring up this map. This came from the New York Times. They did a great article about learning lessons from Thanksgiving to predict what's going to happen for Christmas. This graph, this map, shows who traveled, who had more contacts or less contacts versus 2019 Thanksgiving. And the Northeast region had the least amount of contacts out of any region in the US. New York City itself it was 89.97% fewer contacts the week of Thanksgiving. And they can figure this out because of cell phone data. Why I bring up these two charts in conjunction, when you're looking at this map and you see places where contacts increased during Thanksgiving, you also see the positivity rate now increasing. And that is something to pay attention to for Christmas. If contacts are going to be increasing, it is likely that the positivity rate in those areas will be increasing as well. So those are all the things to be looking out for. We will obviously keep you posted. The governor, his briefings are scheduled for Monday, Wednesday, Friday. Means that there could be a Christmas briefing. But I'll leave it on one last positive note. The governor did say that Santa has a travel exemption to come to New York. So with that, Adam, we don't have to worry about any of that, the quarantine things for Santa. And with that, Pete, I will toss it back to you.
Thanks, Katie. I think Santa engages in social distancing, so it's probably probably okay. Let's turn to Aaron now. Aaron did a webinar with Adam last Friday on the vaccination issues. It is obviously of great interest to all of our clients in terms of where we are and frankly, whether you can mandate it or not, so on and so forth. So lots of questions here. So Aaron, take it away.
Thanks, Pete. And my kids were already told that Dr. Fauci said it was okay for Santa to come, but now that he's got Governor Cuomo's blessing, we are all set in the Torsello household. So thank you, Katie, for raising that. As Pete mentioned, this segment will be dedicated to a discussion on the vaccine and where we stand in terms of the issues that we've been working through for the past several weeks. As I'm sure everyone on this call is aware, we have begun the rollout and administration of the vaccine for the most vulnerable populations throughout the country. That has started to raise a number of questions for employers kind of looking down the road, particularly into 2021, when it's anticipated that the vaccine will be more widely available for as we move through the levels. We have done 2 prior presentations on the vaccine, so this one will be a very quick overview as to what we know and where we stand. If you want to dive a little bit more in depth into this issue, I would suggest that you go back and watch our recordings from our December 8th Tuesday webinar, as well as our pop-up webinar that Adam and I just did on Friday, December 18th. So as Pete mentioned, the issue that we are really grappling with at this point is whether or not employers can mandate their employees to get the COVID-19 vaccine. While there is a growing school of thought that employers can mandate their employees to get the COVID-19 vaccine, I would say that this issue is far from settled at this point. If you go back and watch the 2 prior webinars, we go in depth into the historical context of where vaccine mandates have popped up. Primarily, they occur within the healthcare industry, and they primarily deal with the annual flu vaccine. Within that context, courts have routinely upheld an employer's ability to mandate a vaccine. However, as we know that, there are going to be employers in various industries outside of healthcare that may be interested in mandating the vaccine. And we don't have a lot of guidance as to where that will end up, although we think that it's likely that a court will uphold it. Last week, as Adam and I spent a significant amount of time on in our webinar on the 18th, the EEOC issued updated guidance concerning employers' mandates for requiring a vaccine. While the EEOC did not explicitly answer the question, can an employer mandate an employee or its employees to get the COVID-19 vaccine, it implicitly answered that question. And why are we saying that the EEOC implicitly answered that question? Well, throughout the guidance, the new guidance, the EEOC used certain verbiage which indicated that there was, that employers can make this mandate. For example, the EEOC continuously used the language such as, if an employer requires employees to get vaccinated, they must do X, Y, and Z. So the underlying implication is that employers have the ability to require the vaccine. The wrinkle here, as we talked about in our last webinar, is the fact that the COVID-19 currently is being distributed and administered under the emergency use authorization as opposed to full approval by the FDA. We'll call it the EUA designation, provides certain statutory rights for individuals who are receiving the vaccine. For example, it requires that the entity administering the vaccine give certain disclaimers to the person receiving the vaccine. And it also allows the person who's receiving the vaccine to refuse that vaccine. So the question is, if somebody has a statutory right to refuse the vaccine because the vaccine is only being administered and distributed through this special emergency use authorization designation, Does that trump an employer's ability to mandate an employee from getting that vaccine? I think there's two schools of thought. The one is that, well, if you have a statutory right to refuse, how can an employer require it? The second thought is, well, those two things aren't mutually exclusive, meaning that an employee would still have a right to refuse the vaccine under the statutory rights set out given the EUA designation, but they might do so within the context of an employer having its own rights to mandate the vaccine. And at that point, the employee has a choice to make. This is all to say that I think this is far from settled. I think we will know more in the coming months. I would also note that the EEOC specifically references the EUA designation within the guidance and does not go or take that extra step to say that that designation impacts an employer's ability to mandate employees to get the vaccine. So again, I think it's still an open question, but what I'm seeing just looking around in terms of industry guidance and from other news sources, I would say that the school of thought right now is that it can be mandated, but I don't think it's a settled question. So I think it's still to be determined on that. Once or when the FDA ultimately gives its full approval to the vaccine, I think the question becomes less of an open question. But for right now, given the EUA designation, I think it's still an open question. So if we presume for a second that you can mandate as an employer the vaccine, as we've mentioned in both of our prior webinars, and we really need to underscore here, if you do decide to mandate a vaccine of your employees, please keep in mind that there are two big exemptions to that mandate. We have to allow medical exemptions where an employee, it may be unsafe for an employee to get the vaccine due to an underlying medical condition, or where an employee asks for an exemption due to a sincerely held religious belief. In those two contexts, if an employee declines to get vaccinated, either due to a medical condition or due to a sincerely held religious belief, you as an employer have an obligation to determine whether or not there is a reasonable accommodation that may be provided to that employee to accommodate the disability or to accommodate the religious belief. While the EEOC did indicate that you could prohibit an employee from coming into the workplace, throughout its guidance, the EEOC really encouraged employers not to terminate where an employee declined to get a vaccine, even where they had a medical, or especially where they had a medical or religious requested medical or religious accommodation, but to find alternatives to accommodate either that medical condition or religious belief, which prohibited the employee from getting a vaccine. So looking ahead to 2020 and discussing or thinking about this question to mandate or not to mandate, as I was researching some of the industry guidance and kind of some news articles talking about this anecdotally, what are other employers doing? It seems that the running.
So, we'll get back to Aaron's remarks in just a second, but a couple of things. One is the availability factor. That may take some air out of this balloon, that where you're, when you don't have enough vaccine quantities available to you to cover all your employees, the issue of mandation is obviously not yet ripe. The second thing is that the emergency use authorization, as Aaron has mentioned, at some point, when there's full approval, that may change the landscape. And the third thing I wanted to mention, I think Aaron, looks like Aaron may be ready to come back here, is the possibility of collective bargaining obligations in a unionized setting. And so the things to think about there in terms of maybe we're being proactive in asking these questions, and it's great to be prepared, but there may be some things we need to think about as we contemplate this mandation question. Erin, back to you.
Well, looking ahead to 2021, and as we're considering, do we mandate, do we not mandate? And in my research, just kind of looking around to see what other employers currently are thinking about doing, it seems like the leading school of thought is to encourage employees to get vaccinated without taking that step to mandate it. I think a lot of employers are concerned about the various pitfalls. Pete, you mentioned collective bargaining, which is a really important issue to mention. The other issue that I've seen come up is potential liability. If somebody has an adverse reaction to the vaccine that was mandated by the employer, does workers' comp come into play? And it arguably would. So it seems that right now the leading school of thought is to try and use a carrot to encourage your employees to get vaccinated. The stick may be short of disciplinary action or termination, but certainly, finding ways to encourage and incentivize people to get vaccinated without taking that next step of mandating it. That being said, we have a lot of time, as Pete mentioned, right now, there's not general access to the vaccine. So I think really having to press this issue is probably still a few months away until the vaccine is broadly available. But it doesn't hurt to start thinking about this long term and thinking about what direction you think you may want to go in. The other outstanding issue is whether or not New York State will chime in at any point and require certain industries or certain groups to get vaccinated. So there's a lot of unanswered questions, but we'll keep our eye on it and continue to follow it and update you over the course of the next several weeks and next quarter.
Thank you, Erin. 2 quick points before we sign off today. First of all, we are going to be doing a webinar next week. We're going to do kind of a year in review of our COVID webinars with a look forward. So we're going to try and maybe take a step back and offer a little perspective on it, and also some forward-looking advice. So hopefully that'll be of value. I think we'll plan on an hour next week, because we'll kind of do a little bit more than we usually do. The other thing is we just wanted to wish you a very happy holiday season. From all of us here at Schoeneck King, we really appreciate our clients and our friends. We appreciate you joining us every week, and we appreciate working through these issues with you. So everyone, please have a happy holiday season and stay safe, and we'll talk to you here next week.